to Through the HR Lens, our comprehensive market update that looks at the leading HR trends impacting the Australian workforce. I am Leanne Lazarus, Recruitment Manager here in our 𝗶𝗵𝗹𝗶𝗶 Brisbane office, and on today's edition, we will be focusing on what legislation changes have made the biggest impact in 2025. This week, we are joined by Jonathan Mamaril, Director and Employment Lawyer at South Geldard Lawyers, to unpack the legislative and workplace shifts that have set the pace for HR in 2025. From the right to disconnect and wage theft reform to sexual harassment obligations and psychosocial risk requirements, what legislations have made the biggest impact in 2025? And what new pressures and obligations are beginning to surface as we move into the new year, 2026? As we head into 2025, there was a sense of concern as there were so many legislation changes coming into effect that could see a steep increase in grievances and complaints coming through. Some new reforms meant HR would see several new grievances and complaints coming through, tied onto the ones we have traditionally seen in the workplace. These shifts covered a little bit of everything: right to disconnect, rising wage and super requirements, expanded paid parental leave, intentional wage theft legislation, sexual harassment reforms, and growing expectations around psychosocial risk management. Many of these reforms sparked extensive media coverage, discussions in forums, and numerous webinars. Yet the real impact remained uncertain. Now, as 2025 draws to a close, it's clear the year has been anything but ordinary. But have we truly experienced the full effect yet? Today, Jonathan Mamaril joins us, Director and Employment Lawyer from South Geldard Lawyers, to run through some of the changes that came through, the cases that have led to, and a few lessons we can learn along the way. Welcome, Jonathan. Thank you so much for joining us again and for the final Through the HR Lens in 2025. How are you today?
Good, and thank you for having me, and thank you for having me for the whole year as well, Leanne. It's been a pleasure.
And we look forward to 2026 and all the hot topics that come up. So, Jonathan, 2025 has been an interesting year when it comes to HR with legislation changes, a lot of media around big cases that have been coming through, with so many legislation changes coming into play that would impact not just businesses, but HR as well.
Mm-hmm.
And when we started this year, what legislation change did you think would create the most impact versus what have we actually seen come through?
Yeah, that's a really good question. Because there have been so many changes, it could have been any one of them. However, wage theft was probably the one that we all thought potentially had the most danger. Obviously, so first of all, wage theft is not what the media say it is, right? So wage theft needs the underpayment of entitlements, and there needs to be some sort of dishonesty or deliberate behavior. So it's not going to, kick out honest mistakes to wage theft. You still have underpayment of wages, but it's not wage theft. So just make that very clear. But yeah, definitely wage theft was the one that we thought, at least federally, could be a potential big issue. Sexual harassment was one as well that we thought potentially there's going to be a number of problems. But they're probably the two, along with maybe psychosocial risks and hazards.
Okay. And if we start looking at some of those, so we'll start off by let's touching on the right to disconnect.
Yep.
For anyone that is watching that is not aware, this legislation change gives employees the right to refuse contact from employers and third parties outside of their working hours, unless the refusal is unreasonable. Now, Jonathan, everyone was talking about this, both, small, medium, and large organizations, but have we seen any major cases come through where the complaint has been purely focused on this legislation change?
So the answer to that question is no. It has been connected to a couple of general protections claims. There was one in Cairns, for example, and there's been a few others. It has been utilised in, say, workers' compensation claims by employees as well. But yes, right to disconnect was definitely the one that was talked about a lot, discussed a lot. There was definitely people who had certain viewpoints, whether it was positive, negative, on the law, and people have the right, absolute entitled right to have that opinion. However, the change has probably been more the change in behaviour. And I'll say this in two ways. So although it hasn't had a huge legislative hasn't had a huge legal change as such, so we haven't seen any cases, for example, really, other than what I just mentioned. It's been more behavioural change. So what I mean by that is twofold. One is probably the obvious one that everyone thinks, which is that employers, companies, HR needed to integrate policies, put training in place, maybe a few amendments on contracts, definitely clarity on position descriptions, jobs, what the job actually entails, whether the hours worked outside of normal hours was required or not, because there's a couple of exemptions to the right to disconnect, one of which is you're paid to do it. It's a requirement of the role. So there's a couple there, right? So having clarity on that was definitely one where organizations, employers, and HR really focused on. Okay, so that's one point. And that's probably the obvious one that we all think about. And there's definitely been some change, general change around how that's worked. Now, there's potentially an issue or at least some arguments around the productivity side, but I'll put that to a side. That's not really my domain to discuss, but there's definitely some issues there. The second point I think is more interesting, where we're seeing a lot of the problems around right to disconnect is not necessarily at CEO executive level. I mean, sure, you might have a few people that really push back on the right to disconnect. You simply have to say it's the law. It's not, there's not too much to argue on that front. Where we're seeing a lot of the pushback and definitely a lot of problems in terms of dealing with this new legislation is high performers who are in management or supervisory roles. Okay, so think of, and we're dealing with a number of cases like that, right? Or situations like that. Really high performers, high numbers, high productivity. I mean, just an example, salespeople, right? Really high sales, and then they go into a sales manager role, and their expectations of the people they are managing may be similar to what they were doing. Yeah, bigger hours, on call whenever they need, whenever you need to be, doing weekend work. And the thing is, there's been pushback by people who they are managing. That's where right to disconnect is definitely playing out. And there's no doubt there's been trouble in trying to manage those situations, manage expectations. And so more so the executive level, C-suite, and management level maybe having problems dealing with people who are in those positions who maybe have these really high expectations, wherein maybe in the past that was at least implicitly accepted. Now we do have legislation which in some respects has safeguards to prevent that type of that happening, unless, as I said, it falls into one of those exemptions.
Okay. Now, this legislation came in August of this year. If there's a company out there that hasn't necessarily made change to align with or be compliant with the legislation change, particularly in Queensland or even in Australia-wide, what would you recommend that they do straight away to ensure that they mitigate risks for themselves?
Yeah, so the one I always say to clients around right to disconnect is analyze what you guys are actually doing, all right now. Right as we speak, what is the workforce doing? And you could, do something like a survey. I mean, if you're a bigger organization, a survey. If it's maybe a smaller organization, actually have a look and talk to the people who are essentially at the front line or managing those at the front line. What is actually happening in real time? And then, of course, talking to your management team and your salary team, right? That's important as well. Like, what are they actually doing? What you'll probably find is they are doing stuff that you probably are not aware of, which is very normal. Okay. So then you just need to have some clarity about those roles. Okay. So maybe some of it's job creep. Maybe some of it is the covering for other people that people have left. And, it might be a myriad of reasons, right? But having an understanding what that is, And then the third part after that, of course, is once you have the clarity on the roles, and you actually know what is going to be reasonable, what's not going to be reasonable, what actually is expectations of those roles. And that can then feed into your policies, and in particular, your training of management teams in particular as well. So those are really what you need to do for any organization. And if you have done it and you're thinking to yourself, look, we've had a fresh new batch of staff members, we've hired a whole pile of new managers, we've just acquired a new organization or merged it with another business, this is a good time to do another refresh. And not just with right to disconnect in mind, that is definitely one part of it, but others as well, psychosocial, everything else. But that's definitely should be a prime motivation.
Okay, perfect. And is there any difference when it comes to the legislation if you've got a small organization or a large organization? Is there a difference between expectations from the right to disconnect component?
Well, look, there are of course going to be different expectations. So one, for example, is that if you have actually made an effort, you've gotten some advice on, okay, what is it that we need to actually implement or integrate? So as an example, technology is a great way to utilize in terms of disconnection. Yeah. So whether it's going to be a priority list of if we call you, it's very urgent. If we email you, it's please respond in 24 hours. If we text message you, 24 hours. If we email you, it's okay. Get back to us when you can, right? Or whatever the priority might be. So those types, the expectations aren't going to be necessarily going to be higher or lower necessarily. What I mean by that, and don't take that as that small businesses have all these. Well, they have. There are less restrictions on them, but eventually the right to disconnect will be in place for everyone. Okay, so for those who are smaller businesses, as much as you're going to have some time to actually implement this or have some time to implement this, don't rely upon that. Just have it in place now, because it's not overly difficult. And as I said, the problem areas are not necessarily going to be, at the top level or even owner level. Maybe there's a few. Don't get me wrong. Maybe there's a few, but it's really going to be at the high performer level expectations. That's where the key is going to be. And then just have some training and just have, as I said, just bring it back down to something very simple: clarity on expectations and clarity in the role. If you have that down pat, you shouldn't really fall foul of the right to disconnect legislation.
Amazing, thank you. Now, the next one we're going to touch on is sexual harassment, and this change came in and made significant changes to the legislation, particularly in Queensland, where employers were required to proactively implement a written prevention plan by March of 2024.
Yeah.
In short, outside of what I've just shared, what are the differences in legislation between Queensland and Australia? Is there a difference, and what does that look like?
Yeah, there are. There are some more obligations, and we're actually going to be further positive duty obligations, which were scrapped at the last minute by the state government. So look, there are further obligations, in particular around that sexual harassment prevention plan, which isn't overly difficult to implement. Got to do a bit of training, but it should also really jog people into implementing and refreshing the sexual harassment policies, how to deal with sexual harassment complaints, and anything that sort of touches on that. So definitely psychosocial, and also workers' compensation. Dealing with injury or illness, dealing with grievances. So in real time, or realistically, in practical terms, managers should be able to know what to do if there is a complaint of sexual harassment, because the obligations are, well, there's a prevention plan, so to prevent it, but there's also obligations in regards to ensuring that you take certain steps to deal with that sexual harassment complaint or grievance as well. Some of it's going to be set out pretty clearly in policy. And the other thing as well is, and I say this to organizations all the time, employers all the time, sexual harassment complaints are ones where you really should be getting those investigated. And to be honest, it should be investigated by an external third party. The risk around that, especially around the apprehension of bias, around not discharging your obligations or your positive duty obligations, are too high, especially when it comes to sexual harassment. Workplace bullying, I get, is difficult. I wouldn't suggest that people, that HR teams do their own internal investigations. But sexual harassment, especially if it's dealing with someone in a senior role, should not be touched by the HR team. Now, I know people are going to disagree with me with that. Understand the resources. I get all those things, but I just see it on the other side, how that becomes a problem, because you're now an investigator plus potentially a witness, plus also the person issued the letters of termination or letters of disciplinary action. It is a very difficult situation to be in. So I strongly suggest you don't do that. The other thing as well is, Leanne, we've had so many changes federally as well, which affect all the states. So there was a legislation, for example, recent legislative changes in the Sex Discrimination Act, Section 28AA. And so, look, it's a very recent piece of legislation, but basically it sort of changed the meaning of harassment on the ground of sex. Okay. And this was introduced basically after the Respect at Work report, and basically was designed to capture demeaning conduct related to a person's sex, even when it's not sexual in nature. But that claim to succeed, the conduct must have a clear connection to the person making complaint. And this was tested pretty recently in a case called 𝗰𝗵𝗆, which is very recent federal court case. Now, in that case, it didn't succeed. There was still sexual harassment, but that particular provision didn't succeed. So there are still other tentacles, and as I've mentioned psychosocial again, there's other tentacles that reach out from sexual harassment. And then, of course, you've got the increased Sex Discrimination Commission's powers as well. So there is actually a lot to digest in sexual harassment. And as I said to you earlier, please try not to investigate yourselves. There are too many risks in doing so.
Yeah. Okay. So if HR teams are looking at getting that external or that third party provider to come in and help them with that investigation, would your recommendation be go to their legal team or go to an external actual investigations firm?
Yeah. So usually what should happen is go to a law firm, especially those who specialize in employment law, okay, or experts in that area, and they would then have an investigator, okay. Usually be a external investigator, someone with experience in investigations, so that then advice can be provided on that report. The investigators I know, but the good investigators will always ask the next question of, do you have a law firm or do you have legal counsel that will advise on this report? The good ones. Unfortunately, it doesn't always happen, and it becomes really problematic later down the track. And I don't want to say anything about people who don't ask that question, but good investigators really should be asking that question, and good investigators will have an investigation plan they provide to you. Like, they're the basic tenets of good investigation, right? That's it. If they don't do those things, then you're probably going to have a problem down the track. Yeah. Now, fingers crossed, doesn't go into further litigation, and you might get lucky. But as I've said to you many times, I've said to people on the HR lens, through the HR lens many times, if you are relying upon hope and luck in your in your dealings with employees, then that is not a strategy. It's just simply.
No. Fair enough. Well, look, the next one we're going to touch on, and you really sort of mentioned it earlier on, is wage theft, is another big one. And this is one that we have seen come to light in 2025, but obviously going into 2026, we'll probably see more. But before we actually go into wage theft, at times when I talk to people, the people sort of clump together underpayments, wage underpayments, and wage theft together. So what is the difference in basic language? What is the difference between underpayments and wage theft?
Yeah, very, very easy. So, as I said, media get this wrong all the time. What they say is wage theft, which just for them is just really, really bad underpayment. That is still underpayment of entitlement. So there needs to be, to be wage theft, needs to still have to be an underpayment of wages. All right, there has to be an underpayment of wages, say non-payment of penalties or penalty rates, overtime allowances. It could be that they've just underpaid under the base rate, under an award, whatever it might be. Okay, so it has to be underpayment of wages. So that's step one. But step two is there needs to be dishonesty, there needs to be intention to steal or defraud. It has to be a second element. Put those two elements together, and that's wage theft. Okay, so what makes this quite difficult, obviously, is how do you prove the dishonesty? Yeah, how do you provide, how do you prove that? Now, there have been many cases in the past, many cases in the past, which have involved name brand organizations. I'm not going to name check them, but everyone knows who I'm talking about, where there's definitely been underpayment of wages, underpayment of entitlements. There's no doubt about it. So there's no doubt sham contracting, or it could be they paid them under a completely wrong award or whatever it is, right? But it wasn't done as an honest mistake. It was done deliberately. And that deliberate, those who were deliberate, yeah, they might have got bigger penalties, sure, but there was no other real further deterrent. Yeah. And essentially, this change is because the government, has got sick and tired of it. Okay. Yeah. So the big change with wage theft, and we've had in Queensland, there's other states as well, but Queensland in particular had wage theft for quite a while, but nothing really was done with that legislation. Essentially, it's a mirror, federal. Yeah. Okay, and federally, though, you have the Fair Work Ombudsman usually who would be seeking those underpayments, and then they would pass that. If they find that there's that intention, they would then pass that on nicely, gift wrapped and boxed together, gift wrapped to the Commonwealth of Public Prosecutions, and then the Australian Federal Police to investigate. Okay. The big issue with wage theft, and probably the biggest difference, is why you hear about it a lot, is it is actually it can lead to imprisonment. So not just higher penalties, not just penalties for the company, not just penalties for the individual, which you have an underpayment of wages. It will be high, yes, if it's wage theft. But and I'm talking about the millions, by the way. But there's also up to 10 years imprisonment. That's the big one.
Okay. So, media coverage has been huge. There's been several large pertinent cases this year that have come out, and I think we'll see a lot more potentially starting to see the real ramifications or the penalties or the consequences coming through. But when it comes to that wage theft, for some, potentially some people in business, the thought is that liability would sit, or that responsibility would sit, with the payroll person or the payroll team.
Yep.
Is that the case, or is it more widespread than that in terms of who can actually be taken to task if it is seen as wage theft?
Yeah, so it is more wide-ranging than that. Yes, payroll and finance and CFOs definitely can be held responsible. So can, of course, as you expect, directors and owners, as you'd expect. but also human resources as well can be held liable. Further as well, if you have something like sham contracting, then general protections comes into play as well. So you don't just have wage theft, but you also have general protections. So yeah, the personal liability is definitely there. And and I'm not a superannuation expert, but you've got this same day super as well, which will come into play. There's other jurisdictions around superannuation, but it just goes to show that there is a huge spotlight on wages and getting that right. The problem, of course, as we all know, is it's not that simple. Award coverage can be difficult. Establishing award coverage can be difficult, especially if you're in a manufacturing organization. It's pretty straightforward. But what if you're in a manufacturing organization that does software development, that also has contractors overseas and in here in Australia? What if you've got an organization that's acquired another one which has a totally different award system, or it has an enterprise agreement as well? Is there grandfathering of those rates? And I think people who are watching this, there's a lot of people going, "Yep, that's me right now." Trying to figure out, and it's difficult, right? And that's people who look at it all the time, going,
"Yep,
this is difficult stuff to go through," and I totally understand that. However, fortunately, the federal court still look at this and go, well, there's an underpayment here. Yeah, you've got an advice. You've got lots of advice. It's wrong, but you've got the advice. At least then it stays an underpayment. So they're not going to say it's wage if you do that, right? So if you've got advice and, there's a particular couple of supermarket organizations that might have fallen into that trap, right? They've got some advice and it wasn't quite right. They did the audits, wasn't quite right. Okay, it happens. Got pinged for it, and now they're in underpayment territory. But that's not wage theft. So wage theft is you need to have that dishonesty. So there's quite a few cases. For example, if you think about some of the restaurant cases where there was deliberate underpayment of staff, especially because they're on visas. What the hours they worked didn't reflect their pay. Non-permitted deductions. Those types of things were happening, and to be honest, Leanne, if we're all honest, is still happening, right?
Yes.
That's what wage theft was built for, but it's also built for big organizations or mid-sized organizations who have these huge teams who also ignore things as well. So just because you're going, well, we're not being dishonest, but if you're ignoring it, you're getting advice, or you've even got you've maybe got a particular enterprise agreement, or you've got a particular IFA that says you've got a review every year and you're not doing the reviews, like that will put you in a situation where wage theft now comes into play.
Well, look, talking to a lot of HR this year, there's been a number of organizations that have been doing audits, whether they've done it internally or they've got an external consultant to come in and help them with that, or onto a legal firm. When it comes to that responsibility, as you mentioned, finance, HR, payroll, directors, owners can all be held liable. What about that external consultant? Would there be any liability or responsibility if they've given the wrong information?
Yep.
Good
question. So in the past, there have been a couple of accounting firms that have been held liable for that incorrect advice, incorrect work. Payroll software providers, it's very clear, they're not held liable. So there's a lot of cases that say payroll software providers are pretty much not liable. There might be some breach of contract commercial cases that I'm not aware of. I'm not a commercial lawyer, but I'm sure there might be something there. I have no idea. But in terms of payroll software, no. Lawyers haven't been held liable at this stage. I don't know if there ever would be, but again, it could be a weird case out there that maybe at some point they try and do that. But yes, accounting firms have been held liable, definitely consultancies. A number of HR consultancies have been held liable in the past. And that makes a lot of sense because they're probably a little bit more hands-on in whatever the project might be. So that makes a lot of sense. But yeah, accounting firms, external payroll consultancy firms generally, HR consultancy, yes, they'll be held liable.
Perfect. So if anyone is sort of sitting there going, oh, I think we might have an issue now, if you had to give them the first couple of things that they have to do today to start trying to protect the business when it comes to wage theft, if they are thinking there could be, what would you recommend to them or tell them to do?
So I actually gave this advice to a client just recently, and I just went, look at your, so for wage theft, look at your organization. So wage theft underpayments. Look at your organizational structure. You can see which positions are what we call at risk. Yeah.
Yep.
You're not quite sure what the award coverage might be. Not sure if they're paid under. There's maybe some sort of pseudo contractor relationship that's been put together for some reason. Those are the at risk positions. Identify those and go and get advice on it. Legal advice on it. Yeah. What's the award coverage or whatever the coverage is going to be? Basically do a sample wage audit of some sort. So at least you've done the at risk, what you think is at risk. You've turned your mind to it. You've gone, okay, these are the things. I don't know, it's 8 or 9 positions here. We go, look, it's a bit of a risk here. Let's just do an audit, sample audit. Keep the scope pretty limited. So therefore the costs aren't going to be as big as they usually would. After that, if you get advice that there is problems, then that's when you know, okay, we need to invest in this. If it comes back and says, yeah, just going to make these changes, it's likely going to be something along the lines of, make changes to the contract of employment. It's going to be, change, obviously payroll changes, no doubt. There'll be payroll software, payroll changes, potentially information provided to the payroll software provider needs to change. There might be, needs to be a new industrial instrument like an IFA needs to be put in place, things like that. That's fine, no problem. So if you can then roll that out relatively easly and can explain that, because you'll have that information to provide that explanation, and then potentially do it like a little bit of training for your team, training for your HR team, for your payroll team. And if you're getting problems with buy-in, what I'd suggest is, forward maybe some of this content like this and just go, hey, just check out wherever the timing's going to be. Check out this. Or, let's go see a workshop, and one of the things I'm doing is I'm running workshops for clients where I just go, here are the issues. And what we do is we do it with the decision makers, the executive team, the HR team, all in one. So everyone's on the same page. Now, if they want to push back on any of these things, that's fine. We can push them back. They can push back and have their reasons, and everyone's got the reasons for it. And the answer could be simply, I understand, but it's the law. Or it could be, yeah, I understand what you're saying, but practically this is how we do it. So that's probably the best way I'd suggest to those who are listening right now, because I understand it can be hard sometimes to get approval on these types of projects. The resources might not be there. But if you just try maybe narrowing it down to maybe a couple of positions first, have a look at that, and then go, okay, it's not as bad as we think, or it's probably as bad as I thought. And now we need to deal with it. Yeah.
And look, I think sometimes getting that, like you say, you're doing the training for your clients where you're getting everyone in one room. I know sometimes for HR, they know they raise the case, they raise their concerns, they go to the relevant people, but sometimes that buy-in or that understanding is not there. So hearing it from a third party and also an employment lawyer who knows the legislation sometimes can just give them that little bit of a kicker to do something about it. So that's great work on the training side.
Well, now, I'm also relatively entertaining as well. So I'm not going to put you guys to sleep. So I'm not to my own horn, but pretty entertaining.
And interactive, which is good.
Right.
Now, the last one I'm going to touch on today is psychosocial risks. Sure. Now, from last year into this year, that's been a very big hot topic. There's been webinars, seminars, forums coming out, the wise doing that everyone's been. Absolutely. And there's so much information that's been shared in terms of what the legislation states. But in actual fact, by mid this year, we hadn't really seen a true, genuine case come out. Why is that?
So the reason for it is because it's really contained in work health and safety legislation. Okay. And in reality, it's just been added as part of a more substantial claim. So it's probably in two, maybe three areas, but two in particular. So the first one is pretty obvious: workers' compensation claims. Okay, so that makes a lot of sense. If you think about workers' compensation, traditionally it has always been physical injuries, and then there might have been a mental claim that was added on top. There has been a lot of claims that are being accepted in pretty much every state jurisdiction on just a stress claim or just a mental health claim, which you know, didn't, if you tried that 10 years ago, it wouldn't have happened, right?
No.
So that's definitely happening, and psychosocial has been added as part of that. Yeah, much like workplace bullying and versus reasonable management action, you have psychosocial risks and hazards as well that's being utilised. So workers' compensation is one place. The other place is general protections. Yeah.
Yep.
And again, not the main crux of the claim. So the claim could be you have terminated my employment because I, made a complaint about workplace bullying, okay, or made a complaint about, or made inquiry about a flexible working arrangement. Where we are seeing it is that they've said, then the employer have said, oh, actually, that decision has had an effect on my mental health, and so try to chuck in one of those psychosocial hazards. So that's another one where it has been found. The other one, of course, is discrimination, like a discrimination claim. So that's probably the three main ones. But to be frank, where we're seeing a lot of these claims being really utilized is what I'd call weaponized claims. What I mean by that is employees that are being performance managed or misconduct has been put forward to them as a show cause. This has then been turned around on that person that's managing them. Bullying is probably the main one. It's a psychosocial hazard in itself. But they've also brought up other stuff. For example, too much work or the job demands, as an example. Yeah. So that's probably where I'm seeing a lot, and my team are seeing a lot of the use of psychosocial is really in that context. The weaponization of the claims are turning around. Now, whether it's to buy time or it's to actually push back, whether it's to put pressure on that manager, it could be a reaction. There's many reasons for it, but that's definitely where I'm seeing it more. And that doesn't get really reported because a lot of those matters don't really go into a case. It's a matter of time, though. At some point, it will. But right now, you're probably going to see it more come up in workers' compensation matters at this stage. You might see a work health and safety one. I don't know, maybe. But that's probably where you're going to see it. But remember, it's still in the back of everyone's mind. Like, no matter which way you slice it, because you still have, like, interpersonal conflict is still there, right? So you're going to splice it. And again, and that's putting aside state government, local government laws as well, which are seeing a couple of other little changes around this too. So it's going to be an area that will still grow. But as you said, there's loads and loads of content out there about this. That's fantastic. But in terms of actually what's happened so far, at least from a case perspective, there hasn't been a lot.
Yeah. And look, I completely agree. Talking to a lot of clients and HR at the moment, talking around psychosocial risks, they've said the exact same thing. Is it's been tagged on or has been added to, if there's a show cause letter that's gone out, all of a sudden psychosocial risks get brought into it. So that's definitely something that's on the cards. And as you say, we'll probably will see more of it in the future. But from that lessons learned perspective, I think once we start getting those bigger cases, we'll probably have more to take away from. Do you think that the legislation will be tweaked if we start seeing more of these cases coming through in terms of requirements or?
Maybe. I don't think so, because if you look at the changes, they're relatively connected. So right to disconnect, psychosocial, flexible working arrangements, they're pretty interconnected. The ones that were new are relatively separate, like pay transparency is pretty separate to all that. That's a bit more all on its own. But those three, and even the sexual harassment changes to some extent, are pretty interconnected. So I'm not quite sure if there will be a lot of adjustments to that legislation, at least not in any great way. Look, Victoria made, as those who are in Victoria know, that there's been some changes made in legislation, and it's even more obligations. So, look, I don't think so. I think if anything, I think there'll be more changes.
Yeah.
What will be interesting, obviously, is the further changes they make. Will it be in the Fair Work Act, or will it be in something else? Because there are some areas there which are just not dealt with right now. I mean, a great example is technology and AI in the workforce. Basically not dealt with at all, right? No. And there's talk about different types of changes. Those changes are probably not going to be in the Fair Work Act. It's probably going to be something like the privacy legislation or intellectual property, or something like that. There's going to be changes there, which is outside of what I know, like in terms of jurisdiction. So it's probably going to be something along those lines, not necessarily the Fair Work legislation. But there are areas which are haven't really been touched yet that we do need more clarity. I mean, even the changes around, what is an employee, right? The whole substance over form, all those, like the cases that are coming out are really interesting. And if I'm being frank, potentially is an argument of a little bit of overreach on what a company then needs to do. Like, there's a lot of de-risking that they need to do even just before they get off the ground. Dealing with flexible working arrangements, like with the recent big bank case, like that is difficult to traverse now. Like there's a lot of organizations thinking, whoa, like what do we do with that? And now I have said that particular case, those who know, you guys know what I'm talking about. That particular case is probably a little bit more nuanced. That person was there for a long time. They did the working from home for 22 years. It was working for them, all those types of things. Like there's a couple of factors that go into it. But still a case out there that says, look, you got to, one, you got to get the procedural parts right. So there's, if you don't do that, then, you're going to be in trouble. So you got to respond within 21 days and all those types of things. But the other part is you can't simply say, hey, coming back to work from home, back to the office mandate, it's great for teamwork and collaboration. You got to have something behind that. So it can't just be general statements as well. So that's probably the main thing that come out of that case is just saying these general statements. Whether I agree with it or disagree with it, that's not the prerogative. It basically, the commission said you didn't show us any data or anything. And maybe there is, maybe there isn't. You guys can be the judge of that. But there is data out there, by the way. Just letting everyone know there is some data out there to provide that information. But that it's up to the company, the employer, to provide those reasonable business grounds. So that's the thing. It's a lot of the obligations you put on to an employer, and HR are right at the thick of it, of having to discharge that.
Correct. So as we start wrapping up 2025 and start preparing for 2026,
Mm.
from your perspective, what could be on the cards for legislation and HR next year? Now, I'm going to say, we're not going to hold you to it. It's not going to be gospel, but I am going to ask you to get that crystal ball out, give it a bit of a dust, and give us a little bit in terms of what you think or where the big cases or focuses are going to come through next year.
Okay, so right off the bat, what I'd say is, and I've already mentioned it, so I won't go on too much about it, but technology use in the workplace, there will have to be some legislation around that. Okay, we've had loads of cases where you've got applications being created by AI, and you've got letters of termination created by AI where cases have come back and said that's not good enough. Like it's everyone knows all about that. I'm not going to harp on about it, but there's going to have to be something. But as I said, I don't know if it's going to be in the Fair Work Act. I think it's going to be in some other legislation. That's one. I think there is going to be some really interesting political movements next year, pushed by probably outside of the major parties. One is, which I think is really interesting for those who are involved in enterprise agreement negotiations a lot, is protections around penalty rates. So I know that's been pushed a lot, that penalty rates are essentially protected from negotiation. That may well play a big part in enterprise agreement negotiations and may put more restrictions on negotiations. So I suspect that will be another. Another is, and this is where the practical reality comes into play, protection, potential 4-day weeks being protected, maybe not in legislation, but maybe in awards. That's going to be very interesting if they choose to go down that path. So I'm not talking about someone that gets paid 4 days because they work 4 days a week. I'm talking about someone who does 5 days worth of work in 4 days. The key will be whether that's going to be flexible, right? I think it's coming, but the key is going to be whether it's going to be flexible. So that'll be interesting, because if there is no flexibility, there might be some problems around that and how that's integrated. There are some industries that probably can integrate that much easier than others. But I suspect there'll be some industries that will struggle with that integration. So that's another one. Another one is restraint of trade clauses. Now, they were talking about that a lot this year, about basically avoiding them. So there's 3 types of restraints usually. One is, not poaching employees, not poaching clients, and then the third one being not being able to move to a competitor, basically, within a restraint period. They're not talking about the first two, they're talking about the latter, which is the freedom to move to any other organization as someone sees fit. Courts have always been reluctant to enforce restraints, full stop. They're hard to enforce, but there is a thought out there that's getting some momentum. It had actually got a lot of momentum this year, but nothing really came out, which is banning non-compete clauses, in particular for employees that are under their high income threshold. Very similar to the pay secrecy ban, right? That could be something that could be in place, next year. I suspect that could be something. The other one that I'm going to say is, I suspect there'll be some wage theft prosecutions. So I think there will be people that will be criminally charged next year. I suspect there will be some brand names that will be in the headlines. Whether that's going to be for wage theft or underpayment of wages, I'm not quite sure. They'll be very interesting because we do know that there is serious problems with the payment of wages at the moment. And compounding that now is that same-day super as well. So we will have there will be problems.
Yeah.
Now, I know that there are a number of organizations, external organizations, that are really focused on making sure the payroll software is correct, and also that are, really focusing on the payroll consulting aspect. And I've been doing, at least the ones that I know, are doing a fine job at that.
Yeah.
Really good job at that. But I suspect, they'll need to be engaged a lot more going forward to get things right. And what I'm saying to them, of course, is just make sure you're getting that under legal advice as well. So you're just protecting yourselves as consultants and as even industry organizations. Just do that and play it safe. Don't take any risk if you don't have to take that risk. The other one I'd probably say, Leanne, that I think will see a number of changes is just the employment contract. And what I mean by that is we have had some recent case law that involved a couple of major retail outlets, let's say, retail organizations, where potentially it may lead to us forcing ourselves to make changes to employment contracts. Now, I'm saying to clients right now, don't do anything just yet, because that might be appealed, and we don't know what that appeal looks like yet. What I would say, though, is you still need to, one, review your contract. I mean, I always say this to clients, if you still got references to the Workplace Relations Act, I mean, you know that the contract's old, right? So like those are types of things. Like if you're referring to the Fair Work Australia, like all that type of stuff, get it reviewed, because it probably is out of date. There probably is issues with it. So that's the first thing. But secondly, as well, is definitely position descriptions and job descriptions. Yeah. In particular, those have been there for a long time, and you might have issued variations, you might not have issued variations, but you might have changed, for example, the main things like pay, which makes a lot of sense, bonuses, but you haven't had a look at that position and how to manage it. So they'll help you with things like right to disconnect and psychosocial and all those types of stuff. So that's the other thing I would suggest. Going to the future, we might see a couple of cases on that.
Absolutely. Jonathan, I want to say a very big thank you to you for not just for today, but throughout this year, as well as helping me with my HR forums that we have. And obviously, Jonathan is a director and employment lawyer from South Geldard Lawyers, specializing obviously in the corporate law side, or the employment law for organizations. He also, if you want to follow him on LinkedIn, do so. He also hosts a podcast, which is called the HR Engage podcast, where he talks to HR professionals. So give him a follow. If you have any questions, reach out to him on there. But thank you very much for joining us and sharing your wisdom with all of us.
Thank you, Leanne.
If you are looking to grow your HR career or build your team in 2026, we are here to assist you. Whether you're searching for your next opportunity or just need the right talent for your business, we have you covered. With over 10 offices around Australia, New Zealand, and the UK, we can connect you with the right opportunities to set you up for success in the new year. Contact me, Leanne Lazarus, today at leanne@peopletopeople.com.au or on mobile 0431 819 724. Well, that is it for today. And I want to obviously thank Jonathan for his time and for the information he shared, but I also want to thank all the previous guests we've had on the series this year. It has been amazing hearing you share your knowledge and experience with all of us. And finally, to everyone that has watched a session or all sessions and provided feedback and thoughts through our networks, thank you. And we look forward to you joining us again in 2026.